Hi, Gary DeWaal here, and this is a special edition of Bridging the Week, Midweek, and today is July 17th, 2013. Good afternoon or evening, or good morning if it's Asia. As I reported earlier this week, last Friday, the Commodity Futures Trading Commission issued a final guidance and an exemptive order containing important provisions relating to the definition of U.S. person, the swap dealer de minimis calculation, both for individual entities and entities within a group structure, entity and transaction level rules, and the availability of substituted compliance by certain non-U.S. persons otherwise required to follow CFTC rules. These measures were approved by the CFTC by a 3-to-1 vote on July 12th, with Commissioner O'Malley dissenting, following the announcement of an accord on cross-border swap transactions between the CFTC and the European Commission on the prior day. On that day, July 11th, the CFTC also issued a number of relevant no-action letters to effectuate certain aspects of this accord. In addition, piecing together all these measures adopted by the CFTC last week, it appears that relief from registration as a designated contract market or swap execution facility, or as a designated clearing organization, seems likely for qualifying foreign boards of trade and non-U.S. multilateral trading facilities, as well as qualifying non-U.S. central counterparty clearinghouses dealing with at least certain U.S. persons. If this sounds familiar to the regulation of non-U.S. futures and options, it is. Stay tuned. Okay, let me now give you some highlights to all this stuff. Buckle your seatbelt. This is going to take about 8 to 10 minutes, unfortunately, so maybe get a cup of joe and relax. It might also help, by the way, to read along with materials I've got on my website precisely on this topic. Let's start with the definition of U.S. person. Under the guidance, U.S. persons encompass persons whose activities, either individually or in the aggregate, have a direct and significant connection with activities in or effect on U.S. commerce. This definition includes persons who are not only incorporated in the U.S., but also those who have their center of direction, control, and coordination of business activities in the U.S. Foreign branches of U.S. persons are also persons, U.S. persons generally. The definition of U.S. person includes collective investment vehicles, including hedge funds, that are directly or indirectly majority owned by U.S. persons or who have their principal place of business in the U.S. How do you tell if a hedge fund qualifies for this standard? You apply a facts and circumstances test looking principally at the location of a fund's investment managers, fund sponsors, and promoters, and a fund's sales and trading desks. By the way, this action could be very relevant to master funds with feeder fund arrangements. If this is important to you, check out footnote 204 of the final guidance. However, the CFTC is giving a break to non-U.S. individuals, institutions, pension plans, and operating companies that retain asset management firms in the U.S. to provide a host of asset management and other investment-related services. If these entities are not otherwise within the definition of U.S. person, they will not come within the definition solely because they retain an asset management firm in the U.S. That's pretty good news. How can you determine if a counterparty is a U.S. person? Well, here's a case of the CFTC giving and taking away, sadly. First, you may rely reasonably on a counterparty's written representation. That's the giveth. The taketh? Well, you may have to conduct at least perfunctory due diligence, and maybe more, to ensure that reliance is reasonable under the particular facts and circumstances. Okay, figure that one out. Under the exemptive order, market participants are not required to apply this new definition of U.S. person until 75 days after the final guidance is published in the Federal Register, and may rely on existing relief until then. Now, why is this definition of U.S. person relevant? Because for purposes of determining whether a person has to register as a swap dealer or a major swap participant, it is important to determine whether you are a U.S. or non-U.S. person, and whether your counterparties are U.S. or non-U.S. persons. Check out the specific swap dealer calculus in a separate article on my website detailing last week's CFTC developments for details on the calculations that are applicable. In addition, in the final guidance, the CFTC assigned the 13 categories of swap dealer requirements into two levels, entity and transaction level requirements, and then further subdivided these groups into two subgroups. First, the CFTC says there are two types of entity level requirements. Category 1. These are those requirements related to capital adequacy, chief compliance officer, risk management, swap data record keeping, except for certain aspects pertaining to complaints, and sales materials. And Category 2, these are those requirements pertaining to swap data repository reporting and those aspects of swap data record keeping related to complaints and sales materials and large trader reporting. Then the CFTC says there are two types of transaction level requirements. Category A. These are those pertaining to mandatory clearing and swap processing, margining and segregation for uncleared swaps, mandatory trade execution, swap trading relationship documentation, portfolio reconciliation and compression, real-time reporting, trade confirmation, and daily trading records. And Category B, the external business conduct standards. In general, U.S. swap dealers and major swap participants must comply with all entity-level requirements without substituted compliance available. Non-U.S. swap dealers and major swap participants must also comply with all entity-level requirements, but substituted compliance could be available for certain requirements in the Category 1 of entity-level requirements. Substituted compliance could be available for Category 2 of entity-level requirements, but only where the counterparty is a non-U.S. person. By the way, this will increase the U.S. large trader reporting obligations of non-U.S. swap dealers and major swap participants dealing with non-U.S. persons, and arguably began this additional requirement last week. Well, let me correct myself, last weekend. Likewise, U.S. swap dealers and major swap participants must generally comply with all Category A transaction level requirements, but a foreign branch of a U.S. bank could be eligible for substituted compliance with respect to Category A transaction level requirements for swaps with certain counterparties. Non-U.S. swap dealers and major swap participants also must generally comply with all Category A transaction level requirements, but could generally be eligible for substituted compliance for swaps with certain counterparties. Where a swap is with a U.S. swap dealer or U.S. major swap participant, the CFTC will require the swap to be subject to Category B transaction level requirements in full, regardless of whether the counterparty is a U.S. or non-U.S. person. If the swap involves a non-U.S. swap dealer or major swap participant, Category B transaction level requirements will apply only if the counterparty is a U.S. person. If this all sounds very complicated, it is. But fortunately, the CFTC provides some very helpful guidance in Appendices C through E of the final guidance. And it summarizes all the potential instances of substituted compliance. And for sure, the big law firms will issue even simpler charts very soon. Check them out. In general, the CFTC will permit substituted compliance after determining that the relevant jurisdiction's relevant entity level and transaction level requirements are comparable and as comprehensive as those of the CFTC. It is possible that substituted compliance might be available for only some but not all categories of requirements in a particular jurisdiction. Let's see how that plays out. Applications for determination may be made by a foreign regulator, individual non-U.S. entity or group of entities, a U.S. bank that is a swap dealer or major swap participant on behalf of its foreign branches, or a trade association or other group on behalf of similarly situated entities. Once a determination is made for an entity, it will apply to all entities and be subject to periodic reevaluation by the CFTC. According to the exemptive order, non-U.S. entities potentially eligible to benefit from substituted compliance in Australia, Canada, the EU, Hong Kong, Japan, or Switzerland do not have to comply with the relevant entity and transaction level rules until the earlier of December 21st, 2013, or 30 days following the issuance of a substituted compliance determination. Until then, non-U.S. swap dealers located in these jurisdictions remain temporarily exempt from transaction level requirements with non-U.S. persons and foreign branches of other U.S. swap dealers. Finally, it also appears that foreign boards of trade and multilateral trading facilities that might otherwise have had to qualify as a designated contract market or swap execution facility under CFTC rules are likely to be approved for direct access by U.S. persons for swaps trading without registration, provided such entities already are permitted to offer futures and options to U.S. persons on a direct access basis. It appears that equivalent recognition for qualified non-USA CCPs may also be available, freeing them up from registering with the CFTC as designated clearing organizations once a distinction regarding initial margin coverage between the U.S. and Europe is resolved. Already, two non-U.S. CCPs, LCH ClearNet SA and Eurex Clearing AG, were granted no-action relief to clear certain swaps for U.S. persons without being registered as DCOs for the same time period regarding substituted compliance referenced above. The CFTC also granted no-action relief to 16 foreign boards of trades to extend their authority to list for trading by direct access by U.S. persons, contracts and swaps, in addition to previously approved futures and options. Well, sorry this took so long, and maybe it sounds very complicated, but a lot of what I have said is already in an article on my website describing last week's CFTC actions. Check it out, and don't forget those CFTC appendices. Well, that's it for now. Until next Monday, this is Gary DeWaal for Bridging the Week, Midweek. Have a great rest of the week.